Good.
All right.
Okay. Come on in.
Yeah, the weather's fine.
5th and 12th.
Good evening, folks. This is the January 18th, 2017 meeting of the Guilford Planning and Zoning Commission. We are in the Community Center on 32 Church Street in Guilford, Connecticut. I've got some things to read before we start the meeting. First of all, we want to thank you for attending the meeting tonight. I'm not going to read through this whole thing. I'm just going to say that for public hearings, we have a standard procedure, and all of you that are here that wish to speak or ask questions will have a chance to do that. Some of the items that we have tonight, we couldn't possibly make a decision on tonight, and I also want to tell you that in everything that we decide on, you have the right to appeal to Superior Court. I believe it's in Middletown, from Guilford. Yeah, New Haven, from here. Also, the minutes from tonight's meeting would be available tomorrow in the town building, the building department's office. The will be there, and they'll be available at 9:30 tomorrow. Having said that, I'm going to ask, let me just introduce who's here tonight, and then we'll decide who's seated. Alan Brown, George Underhill, Dick Wallace, Tom Koss, Ray Bauer, Rich Meyer, Phil Johnson, Josh.
What's your name again?
George Kroll, Reggie Reed, Lisa Brewer, videographer Schultz, Peter Schultz. Okay, my name is Tom Koss, and I'm going to have Mr. Wallace read the call to the meeting.
Notice is hereby given that the Guilford Planning and Zoning Commission will hold a public hearing on January 18th, 2017 at 7:30 p.m., the location being the Nathaniel B. Green Community Center, 32 Church Street, Guilford, Connecticut, in the Mononkatuk Room, which is on the second floor, for the following purposes. Mac Management LLC, 299 Long Hill Road, map 73, lot 10, zone I2/R5, zoning map petition to amend the zoning map to eliminate split zoning to make parcel I2. Metro 800 LLC, 800 Boston Post Road, map 47, lot 22, zone TS and R3, site plan revision to add additional medical office/retail building and parking, section 273-97. South Central Connecticut Water Authority, 1115 Great Hill Road, map 121, lot 12, zone R8, subdivision application to cut an 80,306 square foot lot out of 476 acres. The property lot contains a house, septic, and well, section 273-25B. Copies of these applications are available for inspection in the office of the Planning and Zoning Commission, Town Hall South, 50 Boston Street, Guilford, Connecticut. At this hearing, persons may attend and be heard, and written communication will be received. Dated at Guilford, Connecticut, the 27th day of December, 2016. Tom Koss, Chairman.
Thank you. I'm trying to remember who was seated at the last meeting. Were you seated at the last meeting?
I believe so.
Okay. So tonight, we're going to have Phil Johnson sit in as the alternate.
Mr. Chairman,
Yes?
the minute, the notice has something about Metro 800, but I don't see that on the agenda.
It's right here.
I know, that was a legal notice.
That's what?
It's on hold waiting for the zoning board of appeals.
Thank you.
So, Phil, you'll sit in tonight, and that will do it, right?
Wetlands.
1, 2, 3, 4, 5, 6. We need one of these two guys.
Yep.
Which one of you guys sat in on the set for the last meeting? Do you remember?
I think I did.
Okay, so Al, you're on tonight. Okay? Okay, first thing up is Mac Management LLC, 299 Long Hill Road, map 73, lot 10, zone I2, R5, zoning map, petition to amend zoning map to eliminate split zoning to parcel I2.
Good evening, Mr. Chairman,
Thank you.
members of the Planning and Zoning Commission, everybody. I'm Attorney Marjorie Shansky. I represent Mac Management LLC. Representatives of the LLC are here with me this evening, and so is Hiram Peck. Mr. Peck is a member of the American Institute of Certified Planners, and he will be assisting in the testimony for this hearing. I will start, I suppose, by handing out my letter. And an exhibit that I will be using in my conversation with you. Okay. Got that? As you recall, and as you saw, for those of you who attended the site visit last week, 299 Long Hill Road is bisected by an R5 zoning line, as shown here and as was marked out in the field at the site. We are here to correct, if you will, the zoning map to have the zoning line moved to be on the property line. One of the fundamental tenets of the authority of zoning commissions to map and regulate property is to do so in a way that the regulations can reasonably be applied. What we have in this situation is 30,700 square feet of R5 in this 16.5 acre parcel. Under the R5 zoning district, a minimum lot size is 40,000 square feet. So it does not have utility under your regulations whatsoever as an element of this 16.5 acre parcel. How did that happen? So among the things that we're going to discuss with you is your legal authority to grant this request, the history of the parcel, and planning theory that supports the granting of this request and that meets the statutory criteria of consistency with the comprehensive plan. We will also discuss, primarily through Mr. Peck, the plan of conservation and development for consistency there. So I begin, and my letter can be for later reading, or you can follow along, although I'm not reading it to you, but I will follow it in broad outline. A, you have the legal authority to grant this request. When the zoning commission part of a planning and zoning commission acts in its legislative capacity, it has broad discretion. And the factors that it looks at are whether the conditions on the ground are properly reflected by the zoning regulation, or whether historic or future conditions warrant changing the designation. The Connecticut courts, and I've placed a few of quotations in the letter that are extracted from cases, some of which were Guilford cases. The Connecticut courts give broad discretion to zoning commissions when they grant amendments to the zoning regulations and when they grant amendments to maps, because they recognize that it is the zoning commission that is in the superior position to understand when conditions warrant making those changes. So you have the authority. And one of the tenets in the law is that zoning must be sufficiently flexible to meet changing conditions, and frankly, to also reflect historic conditions, which is more the case here. 299 Long Hill Road has been the site of a construction and contractor's yard from time immemorial. A very, very long time. Appended to my letter, I think it's the third exhibit, is a 1956 approval by the Planning and Zoning Commission of the town of Guilford, 1956, recognizing and granting a special permit or special exception to the continuing use of a sand and gravel pit at the site. So what that tells us is that we have evidence dating back to a time that was before the industrial designation of the property that supports the activity as being longstanding. Now, on pages 3 and 4 of my letter, not to jump ahead, but to just refer to them, I have some photographs. The top photograph on page 3 is one of the state aerials. I don't know if you're familiar with the MAGIC website that is maintained by the state of Connecticut, but they have aerials of the entire state from 1938-ish forward at intervals, and they're extraordinarily useful. And you pop in an address and they take you exactly to sites. They're extraordinarily helpful in understanding the history of land use in Connecticut. And so you see that in 1951 we have a totally agrarian sort of activity going on, and it's pre-Connecticut Turnpike. It's pre-Connecticut Turnpike. And as in many instances and in towns all across the state of Connecticut, the inception of the Turnpike has generated changes along the way, because when you have a highway interchange, it becomes a logical node for economic development and higher density activity. Underneath the 1951 state aerial is a segment of the 1953 zoning map, which is your first zoning map. And it shows on the, shall I call it the west side, where the gridded area is the Boston Post Road, and you have actual land use designations of different commercial uses on the left side of the page. But north of the Boston Post Road, including Long Hill Road, which is designated at the top, is all zoned rural. And it wasn't until the 1960s that the Planning and Zoning Commission started to incorporate designations for land that was north of the Boston Post Road. And I read in minutes of the Planning and Zoning Commission in the 60s the adoption of industrial zoning there, and that was sort of the place at which the die is cast. Of course, at that time, Landon was already operating the gravel and sand pit because he has a 1956 permit according him that right. On the subsequent page, I show you a segment of the current zoning map. And the reason I do that is simply to reflect that zoning changes over time, and that the corridor along I-95 has indeed become more and more intensive in its use of development, and that is, again, a reflection of its proximity to interchanges on the highway and the goal of the town to concentrate uses in places so that we can leave other areas of town less impacted and less dense. And then finally, I include at the bottom a Bing aerial showing the subject property and showing the industrial use adjacent to it and the business use adjacent to it. And you know, as you drove up Long Hill Road from the Boston Post Road, there's that little office park on the left. We have changing land uses is what we have. All right, so now let's go back to discuss the history of the parcel. I've given you Eric Anderson's map, originally from 1981 and revised in 1984 and thereafter a little bit. But it was at this map, which is referred to in Mr. Moritz at 325 Long Hill Road, and in all of the land and deeds from the 80s forward, this map is referenced in each of those deeds. And I've appended some deeds to my letter where you can see that reference. And it was through this mapping that the front parcel, 325, was severed from the rear parcel in terms of designating it independently. So this is the genesis of 325 Long Hill Road. And it is 40,008 square feet. The minimum lot area in the R5 zoning district is 40,000 square feet. It is a conforming lot. And it is the creation of the conforming lot that leaves behind in the R5 zoning district the 30,700 square feet essentially unusable. How did that happen? Well, it didn't really matter when it happened, and the reason, as a practical matter, and the reason it didn't matter when it happened is because Landon and Hall was there. Landon, at the time in the 80s, was living in the house, and a succession of Landons lived in the house, and that's traceable through the land records. I can give you the deed references until it was, although it's referenced in the foreclosure affidavit that I appended to my letter as well. They lost the property in foreclosure in 2010. The construction company operated there till about 2007. Mr. Larkins has been operating there since 1994. So we have an ongoingly industrial use at 299 Long Hill Road, which before the 80s included what is known as 325 Long Hill Road, and leaving, when this severance occurred, a vestigial portion of R5 zoning district in the aggregate part, in the master parcel, if you will. Mr. Peck is going to talk about the significance of that remnant parcel, that little piece of R5 that's left on the master parcel, and how it deprives the master parcel of utility under the zoning regulations. And that is why, from a legal perspective, a historical perspective, an equitable perspective, the correct thing to do is to correct the zoning line and move it to the property line, because at all times, the property in whole has been, for planning and use purposes, used together. I think with that, I'll pass this over to Mr. Peck, though I may come back and see you after he's done. And I also want to put the notices in the record.
Mr. Chairman, I have copies of my report. I'd be glad to give those to you. Sure. My name is Hiram Peck. Name of my company is Plan 3, and my office is in Woodbury, Connecticut.
Okay.
Would you like the original, or should I give that to the clerk?
Thank you.
Thank you very much. I'm certainly not going to read my report to you, but I'd like to paraphrase some of the more important points that I think will bring out some of the things that Attorney Shansky has just presented to you. I have looked at the records in the town with regard to the regulations that pertain to this property. I've looked at, obviously, the Plan of Conservation and Development, the Plan of Economic Development, and I've actually visited the site as well. So I just want to put that on the record for background. The summary of my comments are as follows. First of all, the portion of the MAC management property which is currently zoned R5 represents, as Attorney Shansky said, a vestigial parcel. It's not a separate parcel, but a vestigial piece of land which is not able to be used as it's currently zoned, as it does not meet the minimum lot size requirements for R5. And I think that's a particularly important point because essentially, as an R5 zone, it serves no purpose for where the line is currently located. Secondly, the present zone boundary which bifurcates the MAC property is not a logical or rational location for the boundary. This presents problems for both use and enforcement going forward. And the third major point is this, is the fact that the properties were both used in conjunction with the contractor's yard since at least 1956, until approximately 81 or after, is further indication that the placement of the R5I2 zone boundary line as was located in an incorrect location when it was first placed on the zoning map. Zoning map location boundaries are placed in many cases to be coincident with property lines. And I'll give you some information about that from some zoning experts that have far greater zoning expertise than I do. Even though I've been doing it for 30 years, people like Norman Williams Jr., as professor of law at Vermont, has said that the important to understand, and just a quote here that's really critical, I think, that zoning may be defined as a general plan to control and direct the use and development of property in a municipality, or a large part thereof, by dividing it into districts according to the present and potential use of the property. The districts must be described with reasonable certainty and must have definite boundaries so that the regulations may be, and this is important, practically applied. The reason that the practically applied is emphasized is that, as I mentioned to you before, that the R5 portion of this property has no practical utility as an R5 parcel. The practicality in the zoning districts, as Professor Williams has continued to state, are based on things like land usability, the uniform rule problem that is created when a boundary line splits the property. And actually what happens is that the intention of placing a boundary line on a particular parcel or at the parcel line, property line, prevents disorder and prospective economic loss. It's important to understand that while the initial miscalculation or misplacement of this line was not perfectly done or not intentionally done at the time, it certainly presents problems for going forward with regard to the utility of the property. The bulk of the research and the writing on this topic, in many cases, comes to the conclusion, and matter of fact, in most all cases, comes to the conclusion that the mapping needs to be rational. In order to determine whether the boundary line location is rational or not, you need to determine whether the property is useful or not. A misplaced boundary line, in this case resulting in the R5 property consisting of approximately 30,700 square feet, is not usable for a typical single-family residential purposes, given its inability to comply with the regulations. Another item that Professor Williams talks about in some of his treatises is the following, is that the protection of existing business interests is certainly important to properties. Now, obviously, that's more important in a business zone than it is a residential zone, but the fact that protection of existing business interests is one of the underlying facts of where the boundary lines are placed. This is certainly the case in this current application, no question. Photographs showing the usage of the property are attached to my report, and I can explain those in a moment to you. Another person that has written extensively on Connecticut land use law and practice is Attorney Robert Fuller, Judge Fuller. And importantly, Judge Fuller states that municipalities do have the authority to divide municipality into zoning districts. And implicit in this requirement, though, and this is important, is that the districts must be described with reasonable certainty and must have definite boundaries so that the regulations can be practically applied. Again, the practicality of the location of this particular boundary is key to Judge Fuller's understanding and statement there. Fuller further states that the zoning map in most municipalities has zone division lines follow property lines. In some cases, granted that they don't, but in his opinion, his learned opinion, they generally follow the property line. Zoning maps are usually sufficient scale to determine where the boundaries are, and in your case, the zoning map can show you, if you scale it, that it's about 97 feet off the property line. very close. I didn't survey it, but I think that's a pretty close estimate of where it is located. In such cases, computing the location of the zone boundary is not difficult, but it tends to present practical problems of applying the zoning regulations to specific problems divided by the zone boundary line. So again, the practicality and the rationality of it are both important points in the theory of planning. As far as Guilford's comprehensive plan, there are a couple of things I think which are very important. In your section 273-5C, it talks about lots that are in 2 or more residential districts. And while this is not 2 residential districts, technically it's residential right now on both sides of that line. The point is where the boundary of a district divides the lot, as you say in your regulations, on the effective date of these regulations, the requirements in the district which the greatest portion of this lot falls shall control. It's logical. It makes sense that somebody should not be precluded from using their property because the zone boundary line falls somewhere in the middle of their parcel. In this case, however, the zone boundary line is located, as I said, about 97 feet from the rear lot line of the residential property fronting Long Hill. It is clear that the property in question would be unable to be used for typical R5 residential purposes. And this is true for at least 3 reasons. The area of the R5 zone property is not large enough to satisfy the minimum lot size requirement. Even if the area and the access way were added to the R5 lot, it still is short of the 40,000 square feet needed for compliance with that regulation. And the former access way of the MAC property shows that the current residence has historically been part of the property zoned I2. For this reason alone, the failure to be able to use the property for typical single-family residential purposes as it's currently designated in the R5 zone is a substantially enough reason to move the R5 I2 zone boundary line. Sure.
You have an idea of when that was split?
1981.
1981, and for what reason? Does it have the rationale in it?
Well, there's
To sever off a area conforming residential lot.
Well, how many square feet in that spin-off have you got there?
The residential lot
To
is
the R5 thing.
40,008.
That's about an acre, isn't it?
Pardon me?
That's about a building acre?
It's about a building acre under your regulations, 40,000 square feet are a building lot.
And you're asking us to make it industrial?
I beg your
Are
pardon?
you asking us to,
No.
what are you
No,
asking us
sir.
to do here?
the,
Let me- here, to make sure it's clear. To clarify, this is 325 Long Hill. This is the 1 acre or the 40,008 square feet lot. This is the rest of 299 Long Hill Road, and this area is zoned R5 on the master parcel. We are asking to move this zone line to the property line.
Because,
It's unusable,
okay, thank you.
it's split zoned, it's impractical, and while it's not a general designation that I would say, there's a confiscation element to saying, gee, it's not eligible for use as an R5, and gee, you can't use it for the use that's been in being for over 50 years, 60 years.
with regard to the town's plan of conservation and development, there are a number of sections, and I'm not going to go through all of them in detail. They're in my report. But there are a number of sections that talk about the economic development must be actively promoted by the town. There are some infrastructure facts. The availability of infrastructure to support community development is critical. As you saw, if you went on the field trip on Saturday, the property is being used for a use which is actually supportive to emergency services. Natural gas is serviced by natural gas is serviced in the town by Southern Connecticut Gas Company. The service area is currently limited, but hopefully the area would be able to be expanded slightly in the future. Also, we think it's important that it's important to your plan of conservation development states, it's important to support the provision of a variety of energy production and distribution facilities. And the plan is fairly clear about that as well. Another document that the town did in 2004 is the Economic Development Plan. And this particular plan specifically references this parcel and these parcels, and it talks about the overall property then owned by Landon that could eventually be the site of some further economic development activity. Hubbard Road is noted in the plan as follows. It says 2 lots owned by John and Agnes Landon, totaling about 17 acres south of, I'm not sure if it's Fonticello or Fonticello property. The area has a small frontage on Long Hill Road, same property. It also has a significant area of ponding, which is currently still there, caused by past gravel excavation. However, small buildings could be effectively located around this water feature in an attractive environment. So it was thought about even at that time, back in 2004, that further economic development could take place on this property. And so finally, and I'm happy to answer any questions you might have about this, my recommendations and findings are as follows. One is that based on the research that I did, the MAC Management R5 property is a vestige of the misplaced zone boundary line. And it's actually interesting, too, if you look at one of the photographs that I've attached to my report, there are a couple of different sort of iterations of where the zone line's located on the property next to this property. The current zoning map, the official zoning map that's dedicated, that's called out in your regulations as the digital zoning map, shows the zone boundary line straight across the property, about 97 feet off the rear property line. However, if you look at the GIS map, which I fully understand is not the controlling map here, it's a bit confusing because that accessway or tongue that comes out to Long Hill Road is shown as I-2 on the GIS map. So that's confusing as well. So there's some confusion there that needs to be straightened out as well. Secondly, the abutting residential property had historically been used as part of this industrial operation. This point gives further evidence to the original incomplete consideration of the matter when the I-2 zone boundary line was placed so as to bifurcate the MAC property. On the corner of Hubbard Road and Long Hill, there's another single residential property as well. And if you look at one of the photographs, again, attached to my report, it looks like when the original boundary line was placed in that area, the I-2 boundary line, that it went directly off the back, that is the rear portion of that residential lot that is on the corner of Hubbard Road and Long Hill. And it looks to me as though what happened was, as dedicated as you all are and staff is when you try to locate these things, there are so many parcels in town that somebody probably said, well, let's just make the boundary line even with Long Hill Road or parallel to Long Hill Road off the back of that particular residential property, not realizing that at that time when you did that, you caused this particular miscalculation with regard to where the property line is located now versus the boundary line. The third thing is that the MAC property, which is zoned R5, has no rational way of being used for typical R5 purposes. Now, typical R5 purposes means a lot of things today. And if someone came in and said, well, we want to divide this property and we want to use that 30,700 square foot piece of property for a single family dwelling, the answer from the commission would probably be no, it doesn't conform. Go to ZBA. ZBA could say, well, yes or no, but the fact is it probably would not be able to be conformed to the current R5 regulations. Other things could be proposed there, but again, that's probably not in keeping with either this discussion this evening or the industrial use of the property. Number 4, the recent site plan approved by the commission will have no significant adverse effect on the owner of the R5 property or the R5 property itself. The current existing buffering between I-2 use and the R5 residential use is visible evidence of the ability to screen the abutting uses from each other. And I fully understand, too, that there's a question about whether the fence is the proper height or not, but that'll be addressed at some point in the near future. Support and, in fact, encouragement, number 5, for the use of the I-2 property for economic development purposes is what the Southern Connecticut Gas Emergency Substation realizes is found in the comprehensive plan, the 2015 Guilford Plan of Conservation and Development, the 2004 Guilford Plan of Economic Development. And finally, number 6, the relocation of the I-2 zone boundary line approximately 97 feet westerly will establish a properly located zone boundary line that will permit future rational and practical decisions to be made regarding the uses of the property. And I put the sources of the information that I got for planning theory in my report, along with several photographs and maps of the zoning boundary location as it's currently located in both the zoning map and the GIS system. So if you have any other questions, I'm happy to answer those.
I've got a question.
Yes, sir.
So, we talked about this being in continuous usage as a building lot, and yet we also talked about something about a foreclosure. Before Mac Management bought this parcel, what was the use of the parcel? What was it being used as?
It was 325 that was lost in foreclosure, the residential 40,008 square feet. 299 Long Hill has been in continuous use as a contractor's yard construction company from the 1950s forward.
So continuous use means that it was used for that purpose, not just owned by the company. And the reason I'm asking, Counselor, is that this came to light when it became visible from Route 95 that there was a lot of activity going on the lot, that there was now going to be storage of gravel and things. And it probably coincided with Mac Management taking it over. But I don't recall seeing anything on the lot beforehand, but you're saying that it was in constant usage.
Emphatically so. Until
Yep.
2007, Langdon and Hall were there, and in 1994, with them, Mac Management took occupancy as a tenant. So it has
So-
been used continuously. And if I may, and I want your next question, but I want to go back to this map, just, and I want to go over here so as not to block it. I want to make clear that this is the house at 325. No, sorry, this is the house at 325, this is the house parcel, and this highlighted line was the access into the rear, over the house parcel,
Right.
okay? So the whole parcel was in use.
And finally, one more question, Counselor.
Yes, sir.
When Mac Management purchased the property, it was aware that a portion of this property was zoned R5?
I do not believe so. We can inquire, because I will tell you that if you look at the assessor's card, which I'm happy to make part of the record, it says it's I-2. He pays taxes as an I-2, probably for the same reason that the GIS says I-2. And here comes a copy of the assessor's card for you. It was not understood that it was split zoned until the neighbor came forward. Yes, sir.
So, two dates I'd like to get established. When was the zoning line established? Do we know when that was?
Not exactly, but the discussions in the minutes of the Planning and Zoning Commission in the 60s were adopting an industrial line.
And when was the property subdivided to break out the residential parcel from?
I would call it a first cut, and it was 1981. It wasn't subdivided. That would be 3 lots.
So-
It was cut, a first cut, pre-cut.
Thanks, Mark.
But as I say, because it was in continuous use, before zoning was adopted other than rural, the mere imposition of the zone line didn't matter until the residential parcel was carved out. And from that time until now, it has been a latent defect.
Question for you, Counselor. When we say constant use, it's a broad term.
I beg your pardon?
When we say constant use, it's a very broad term, and it implies that it's a constant amount of use. Has there been an acceleration or an increase in the use of this lot in the last 2 years?
It's a conforming use, so
Right. Has
what
there been
I
an
mean by
increase in it?
constant use is that there's been continuous use industrially without cessation.
Could you answer my question, please? Has there been an increase in the amount of use?
I would have no way of knowing that.
Who would know?
I
can't ask you that. This is important to me.
I beg your pardon, but I'm just not sure what the relevancy, are you talking about the use of the 30,700 square feet? Are you talking about the use of the 1 acre that this commission unanimously approved erroneously in July, you know?
I guess what I'm asking is that, if there was a certain amount of use for the last 50 years, but more recently, there's been an increased use right up against the property line through an error of ours because we had wrong information. That also flavors the path forward. Your statement that it was in constant use implies that things haven't changed that much, but there's been a change.
No, you're conflating, if I may, 2 issues.
Yep.
If you want to move ahead to the subsequent use or the further correction of last July's action, we can do that. But the relevant inquiry for this petition has to do with the location of that lot vis-à-vis the history of the parcel, good planning practice, and the fact that now that it's been identified and understood, it has a chilling effect on the use of the property.
But it would also have a direct impact on the neighbor. Moving an industrial use all the way up to their property line when it had not been there, while it may be in conformance.
Not necessarily. And the reason I say that is because over time, through the amendment of your zoning regulations, you have very definite stipulations about boundaries and setbacks when there are zoning districts, diverse zoning districts that intersect. So there are built-in protections in your zoning regulations. That having been said, the total eclipse of the 30,000 square feet leaves the property owner with no place to go. And that is the effect of leaving it R5.
Could I just mention too, the point that I brought up about the abutting residential zones, your regulations are clear that when there's two residential zones that abut, which is in the case, there are R5 and R5. Both sides of that property line right now are R5. Your regulation says that the majority of the property, that is a larger portion of the property, is the use that's allowed to continue. I'm not going to make the argument that that should be a residential zone. I'm just pointing out to you that's what your regulation currently says. With regard to the amount of use, I think that the property has been used, I know the property has been used since at least 1956 for those purposes, the contractor's yard, the excavation yard. That permit, 1956, was not limited to any specific portion of the property. And there are lots of cases, and I'm not going to talk about law because that's not my place here, but there are lots of cases that talk about that use of that property goes to the extent to the property lines. It's not limited to a specific area.
I had a question. Well, I had two sort of questions, and I think mostly for Mr. Peck. So, first of all, are there any times when, or in your experience, when split zones are acceptable or necessary? And can you give us some examples of that, if there are any?
I think there are a lot that exist. There's no question. You know, if you look in a lot of zoning maps, you'll find that there are split zones. But typically what happens is some problem comes up with regard to the use of a particular property, whether there's a town line in the way, or a property line in the way, or a zone boundary line in the way. And the idea, that is the theory of zoning, according to Williams and Bob Fuller especially, you try to eliminate those wherever possible. So I think that trying to minimize those discrepancies, that is that original miscalculation, is the best thing to do.
So there's never sort of an intentional split zoning? Is that what you're saying?
I would say from a practical standpoint and from a rational land use standpoint, it's not a good idea to do that.
And my other question is, you kept talking about how the property is not usable as a residential property because it doesn't conform to the 40,000 square foot that an R5 would conform to. I mean, isn't this and I'm not asking you to speculate as to what our ZBA would determine, but isn't this the quintessential hardship? I mean, wouldn't this be the absolute time when hardship would be applied? I mean, the ZBA throws around hardship for a lot of different things, but I would think that this would be an absolute hardship for an applicant who has a 35 square foot. Okay.
That's a legal question.
Okay, go ahead. Well, just he has such great experience in the zoning area. I figured he might have seen it 1,000 times. So but you could go ahead and answer.
Well, I go to zoning boards all the time, and I will tell you that that is a discussion point that is very important, that this is an undersized portion of the master parcel. You can't force this landowner to seek a variance to put a house on that parcel.
No, certainly. I'm just saying, the argument was that it's effectively not usable, but, I mean, as it sits right now, it certainly is effectively not usable. He can't just walk into town hall and ask for a building permit and put up a 2,000 square foot home on this non-conforming site. But if he wanted to do that, he could go to ZBA.
No, you really can't, because it is an integral part of the 16 and a half acres that has been in continuous industrial use. So the fact that by an accident, let us suggest that it was intentional, let us suggest it was an accident, it didn't matter, because at the time it was adopted, it was a fully industrial parcel. And so this is just what happens. I mean, when Mr. Peck talks about you find split zones here and there, in some cases you find a split zone emerging because of property transfers over time where somebody assembles a parcel and it's partially, in fact, when you all did the rock pile, that had 3 zones and an overlay, right? I think it was 3 underlying zones and an overlay. And you sought to eliminate it through your rezoning. We're seeking to eliminate through the rezoning, but there was a use in being. This isn't the product of acquisition of additional property. This is just what happened when you funnel the passage of time on the existing landscape, and we're trying to correct it.
Saying. So I just want to make sure that I fully understand, you know, the effects of the ZBA here. So you're saying that the ZBA would not be able to approve this site for residential use because the majority of the site is industrial?
I would say that we cannot speculate on what the ZBA would do. But after the Varillo case in 2015 and E&F and the succession of cases at the highest courts in Connecticut, the availability of variances has become even more constrained. But moreover, he shouldn't have to do that to get to use his property.
that part of it.
He's using his property, and with respect to Commissioner Meyer's question, whether or not there's intensification down the hill, it's irrelevant. It's a conforming use. He has full permitting from the town. So we have to be very careful when we, sort of start labeling that kind of thing. We're really here on a mapping exercise, and I understand that there's...
Your position was, and that's what I'm just trying to poke at, and I'm sure we'll hear from here. Your position is that you might be right, is that 35,000 square feet can be used for nothing at all. And I'm just trying to figure out if that's actually the case. It can be used for absolutely nothing, other than, unless we made it an industrial. So I just want to know, is that really the case?
I'm not sure. Oh, I feel like one of those people being interviewed at the Senate. I don't think it's a question that one can really answer. I think that what we're doing is analyzing the existing status of the property against your existing regulations to demonstrate the illogic and unreasonableness of 30,700 vestigial square feet that are left over after a conforming parcel was made at the streetscape. Let's put it all together. And I would go so far as to say that if elsewhere in your regulations that if you have 2 zones and one's got the bigger part of the property, I would argue that would weigh in favor of this being I-2 under the thought process existent in your regulations.
Thank you.
I don't think that's a remote conclusion to draw.
At the time when the parcel was cut, would it have made more sense, in your opinion, to cut it up to the point of the residential line?
No, and I'll tell you why. Although, again, this is speculation, but I'm happy to respond to that. If you are armed with the book that says I need 40,008 square feet to get a conforming lot, and I have a business operation that is still in use at the rear of the property, I'm going to comply with the zoning regulations for the residents, and I'm going to leave the rest. There's nothing that compelled them to do that. I don't know what their thinking was,
By
but
having the smallest possible lot.
the conforming
when the
lot,
line was already in place at the time.
the conforming lot.
Right, I'm not saying it's not, but if it were larger than the 40,000 square feet, it could still be conforming, but it would also...
Oh, there's no question about it, but the economies are that there's more productivity in the industrial land than there is in the residential land. And now we're totally like speculating for the Landons because it was all theirs at the time. But if I'm the Landons, actually using the house in connection with the construction business at some point, that came from Eric Anderson, who did the survey, and I want to now sever it off to make a residence, which is then going to pass from Landon to Landon, which the land records clearly reveal, I'm just going to take what I need to do that. Also, because of bank lending, you need to have a conforming lot in a residential zone to get the mortgage for that property. And the rest is staying in operation, in the existing operation as the construction and contractor's yard. It's totally logical. Because more, you know, if you looked in an assessor's card, for lots that are over the required lot area in a zoning district, the assessor calls it excess land, right? So why create, from their perspective, but more taxable land from the owner's perspective. So this is all I need to get a buildable lot. It's what I'm getting. And I'm sure it's not the first time that the commission will have seen lots that simply conform, because conformity is conformity.
Can I ask a technical question? If this were a building lot, from all the boundaries that we walked, what is the setback on either boundary?
Residential building
Yeah.
R5?
Would be 50 feet
50
all
feet.
around.
So if you drew a 50-foot line from all the borders of that,
You don't have a house at all.
I don't know what kind of a house you could build that would actually work there.
Right, you'd have a bowling alley, except not even, because the setbacks overlap. So let me answer your question more directly, Mr. Commissioner. No.
I don't have any questions now, but I'd like to hear the opposition's case.
Sure.
It's something-
If you guys are done, right?
Thank you very much.
You guys are done?
Are these
Yep.
lots taxed separately?
No, George,
Well,
they're not.
I just want to hear what they have to say. and
You just-
I'll come back with questions.
Well, one's an acre, and the other one's 17 or 16 in the
Yes,
fraction.
in that case, they are, but the piece that is actually residential Mark is paying taxes on that,
As in industrial land.
as industrial.
Yep.
Yes.
The assessor makes no distinction
Guess you guys are done?
for the moment.
Okay. Sir, please introduce yourself.
I'm Attorney Matthew Rubano. Good evening, Commissioners and officials. I represent Carl Moritz, who is the adjacent property, residential property owner that you've been talking about tonight. But in addition, I also represent Mrs. Alvania Fitzhugh. She is at 361 Long Hill Road, which is the residence just one parcel removed, or better part of a section of a parcel removed, to the farther down Long Hill Road to the north from Mr. Moritz's property. She also sees much of the usage pattern that has been talked about with respect to the July 2016 approval of the site usage, of the site plan for this property. This portion of the larger parcel, which is the Southern Connecticut gas portion, 1 acre, where part of it, as Attorney Shansky and Mr. Peck have indicated, has R5 residential zoning within it. It's about 97 feet of it from the eastern boundary of Mr. Moritz's adjoining property. And that's the rub. He's right up against this section of the 1 acre parcel portion of the overall 17 acre or so parcel, which has been designated for usage by Southern Connecticut Gas Company as basically, depends on what you want to call it. Originally, it was approved as a satellite office. Is it really an office? Well, there's a building there that could be used as an office with electrical, new electrical run to it, also gas for heating in the office. But what else is it? Well, it turns out that it's actually a storage yard for aggregate materials, sand, stone, other aggregate to patch holes and various things that are areas that are dug up in the course of Southern Connecticut Gas's operations in the area. But also, it also houses, it's a service area, a service yard, where we have various vehicles, commercial vehicles, Southern Connecticut Gas vehicles, about 4 of them to be exact. They're parked there during the day and through the night, and the next day, you know all this for the most part, I'm just giving you a refresher, because it goes directly to what it's like to live right next to that for both Mr. Moritz and Mrs. Fitzhugh. Those vehicles, those large, heavy industrial vehicles, 4 of them, are used by 4 different employees apparently who drive in with their own commuting vehicles, park them there, take those commercial vehicles, use them on the site, and leave the site to go after they've gotten aggregate put in them. There's one is a backhoe to put the aggregate into the machine, into the dump truck basically, and it drives off to the location where they're headed. There's another utility vehicle of some sort, and there's 4 commercial vehicles, all heavy equipment type vehicles. Point is, they drive right by Mr. Moritz's property and also by Mrs. Fitzhugh's property every day. Is it light usage? If you live next to it, I don't think you'd think that, but we'll get into that. That's separate. That boundary line, however, was established historically, we would posit, for very important practical purposes and reasons, based on the fact that you had these adjoining residential properties to this larger sand pit, as it's been called, almost 17-acre parcel, all of which, as Attorney Shansky has said, was owned at one time by Landon and Hill, and Jim Landon, I should say, and then Landon and Hill. Construction operated out of there, but that's a checkered history too. It wasn't continuous, as I have heard here tonight, not even close. It also wasn't wholly for sandpit operation purposes. Back in 82 to 87, it was a BMX biking trail. Those facts are material to the argument that's been posited that creates a legal basis for this decision to be rendered in favor of the applicant in terms of the amendment of the zoning map to move that I-5 zoning boundary right up against Mr. Moritz's eastern boundary line to his property, right out his back windows on all 3 floors of the house. And also, clearly visible from Mrs. Fitzhugh's residential property, no more than 200 yards away. Taking a gander at that distance, I can't hit a 200-yard shot in golf anymore, so it seems pretty far to me. But it's actually not that far, 600 feet. Okay. Carl's going to address the history of the property that he has known it. He bought it about 6 or 7 years ago. That carved out portion of the overall Landon property, of which Mac Management owns the nearly 17 acres now. And he, Mr. Moritz, owns the 1 acre, roughly 1 acre residential property, a historical property at that, as is Mrs. Fitzhugh's, by the way, but I'll get back to that when I come back up. Carl, you ready to talk to the commissioners? If you have questions for me now, I'd ask that you actually hold them for when I come back up and talk about the law, unless you really need them.
I want to hear your whole case.
Carl Peter Moritz. I'm very interested in the history of my home. It was actually built by a descendant of Captain William Chittenden, who signed the charter of this town. The Landons took over the property, I believe, in 1920, and I believe my house was built around 1845. It is a house on the historic survey of Guilford. Passing that around, but that's evidence that it's on that historic survey, as well as Mrs. Fitzhugh's home, who she says, despite what it says on the survey, her house was built in 1739. George Washington was still alive at that time. And in 22 years, it'll be 300 years old. It's on the corner of Hubbard and Long Hill Road. And she's subject to, fortunately, a lot of disruption by the traffic on that corner. A lot of the heavy traffic, or the most disruptive traffic, is from the heavy trucks that pass through that area, as well as my house. Anyway, so here's a copy of her home is on that registry, and that would mean that certain regulations are going to apply to to the property, including Mr. Larkin's property. Because my home was put on that list when it was a single parcel, this barn is subject to the demolition ordinance that we have. I wrote a letter to Mr. Helander, and he confirmed that even though the parcel was split, it would still be subject to that ordinance. My speculation that the property was divided because of the BMX bike track that existed in the sand pit area from July 29th, 1982 to September 4th, 1987. Footland BMX Complex, nonprofit organization. The filing status currently is forfeited. I have the file number. Marilyn Landed was the agent for that company. Here are the state records that show that they operated in that sand pit. There's actually a YouTube video of the bikers racing through there. It's bicycling. They were known for their over-under. They had an underpass and an overpass. I guess the track had like a figure eight somehow worked into it. Somewhere in that sand pit that's supposedly under heavy industrial use. There was a bike track back there. I had somebody knocking on my door once, wanting to go back there and like see if there's anything left. If they can go into the bike shop, that is probably this structure here was the bike shop. It used to have the concession stand in there. I told them I didn't own the property. Kind of looks like I do. So I told them not to go back there. At that time, the Landon still owned the property. When I bought my property, John and Agnes Landon, Irrevocable Trust, owned the sand pit area. And before Mr. Larkins purchased it, it went into a trust of the four kids that they had, which included John Landon, Sheila, Kevin, and I think I'm missing one. But anyways, I had some direct contact with Kevin Landon, who oversaw that JSDK Corporation, I think they called it, or LLC. So anyways, my speculation is that they divided it up for liability reasons, so they could put their BMX bike track back here. I don't have any photographs, aerial photographs of it. I don't have any that kind of make it look like it's a bike track. They don't go back that far. I mean, if you go back to 1938, you'll see that it's all farmland. It's all level grade. But yes, Landon and Hall did operate as a construction company. I have their permit, or I have their Connecticut license starting on April 11th, 1947.
The BMS complex, does that operate as a business, or did they make revenue from it? Because it shows it's a non-stop corporation. Usually those are nonprofits or something. I was just wondering.
If you Google it, you'll see a lot of hits on the forums where guys are talking about, hey, remember back then? Oh, they were great. There's a picture I have of a whole bunch of trophies out in this area. I have a picture of people standing in front of the concession stand with their bikes and everything.
And you're saying that at the time it was that they didn't do any construction or heavy industrial type work there?
All I can tell you is that a BMX bike track ran out of there for 5 years.
Did it run along with the other uses, or?
I can't tell you that. But Landon and Hall did have, they were operating. But they largely operated out of this area, from what I can tell. The barn was full of construction materials, doors and trim and all kinds of stuff like that. So, A&W Sanitation that operates back here, he was kind of restricted. And he was egressing and ingressing off of this, what I used to call the dirt road, which was improper. This area here was dormant. I came along in 2011, May 2011. This area was dormant. So when Jeff Landon owned my house and who lost it to foreclosure, he and his family, they used this area for recreation. And I'll pass around a photograph that shows, I have a few copies of these, this is kind of a good one. So you'll see all the buildings labeled. Most notably in that area is a volleyball court, a greenhouse, gardens, and a field. Not industrial use, residential use. Need an idea what to do with a residential property? Well, maybe play some volleyball or park some passenger cars there. That seems to be okay. Is it that hard to come up with those usages? I'm not an expert. Here's a picture of that area before that greenhouse was demolished. I thought I had more. I think I ran out of photos. And to answer the question, has there been expansion of the activity? There's been massive expansion of that sand pit, most of which I understand operated without a permit for about 20 years, from what Mr. Landon said at his permit hearing. So yeah, I knew there was a sand gravel pit operation when I bought the property. I'm sorry that Mr. Larkins didn't know where the zoning line is. He's in the land development business. Can afford an attorney. So, anyways, I don't know if I have much more relevant history other than that. That shows that, yes, Landon Hall went out of business. Their license expired in 2007. They filed for bankruptcy in 2008. From 2008 until this summer, that's 10 years where there was no industrial activity in this 1 acre area. None. I'm there every day. I live there every day. I see it. I know exactly what's going on. I work there every day. I can hear them from the front of my house. I hear this activity that's now there. Here's the 19th century carriage house that was demolished. We were standing out in that field, or where that building was. Since it's too small of a structure, it was not subject to the demolition ordinance, but certainly wasn't described properly on the site map. It's described as a shed. Part of the view I lost, that's part of the screening I lost. Behind that now I have that bird's eye view of the porta potty. Still there. So, has there been expansion? Better believe there has. Mostly since Mr. Larkins and Mac Management took over, they pretty much deforested the whole area back there. I thought I had more of those other pictures, I'm sorry. So, yeah, we live with a lot more traffic than we do. Anyways, let me just review my history sheet. So, the foreclosure was in 2010. I bought the property in 2011. JSDK was formed and owns 299 Long Hill Road. So in 2011, from 2007 to 2011, there was no activity up there. There was no construction activity. It was an old volley, it was all overgrown. There was a lot of sporting equipment stored in that greenhouse. I don't know what else to describe it. Kind of indicates that there was a lot of recreational activity. There also was a trailer full of canoes. Need a use for residential area, do some recreation.
Let me ask you this, the intensification of the use, it still is conforming to what they're approved to do. In other words, their intensified use is not violating any approvals they have for that property,
Well, it
right?
depends on what regulations I can see it now. The sand pile is so tall I can see it above this, the white building, the
No, but there's
so-called
no
workshop.
specific zoning regulation you can cite that says they're in violation of it.
Well, there has to be, from what I understand, there needs to be adequate screening from the industrial to residential zone. There's no screening. If I can see it.
Then is that a zoning violation right now?
You're the zoning expert.
Well, no, that's what
I
I'm-
think so. I think so.
I'm asking you, that's why
Yes,
I'm trying to.
I think it
get
is. Well, as well as in other areas.
Well, maybe your attorney can,
Yeah, maybe.
has
So,
it in his argument.
Are there any
what-
questions
what's
on the
being violated.
history? So 2011, we had Hurricane Irene. I had to write to Kevin Landon in 2012 to get A&W Sanitation to use the proper right-of-way. He wasn't using the proper right-of-way. Took 2 months. Some other issues too, I won't get into right now. Any questions on the history? Right, yeah, so it's the Chittendens, they were chicken farmers. And the story is that, that I heard from 2 people, that Agnes Landon said, either I go, or either the chickens go or I go. But I haven't seen any evidence of chicken farming structures in the old aerial pictures, but that's what I
Thank you, sir.
Thanks.
Thank you.
Commissioner Bauer, while your question is fresh in our minds, I want to address that, and Carl, maybe just hang out for a second before you sit down. This is a photo from, I believe, the second story bedrooms, or one of the
Yes.
bedrooms, I should say.
Right, yep.
But also visible
Yeah, it's my
from the
bedroom.
first story bedroom. Carl's bedroom, down into what's called the sand pit, the large bulbous area where the operation, the construction not the construction operation, but the sand pit operation of Mac Management and Mr. Larkins, him as their representative, operate. This used to be invisible until various screening trees primarily were taken down. Now that's his view.
Right, but my question is.
And is it in violation
Yes.
of any regulation? Okay, I'm going to hand out to you. There are 2 key areas I tried to address to not get too much out there and confuse matters mightily. Let's see. Looking for my original. I might have just handed it out with the pictures or no? Oh, here it is. Chairman Cost, I'll give you the original. Or are you? Oh, here, sorry. These are copies of my letter to the commission, brief memorandum in opposition.
Do they have a copy of this?
I have copies for them. I didn't get down to the town hall office earlier today.
Okay, so we want to make it up for record. Thank you.
Sir, can I ask you a question? Did you make
I
any
will give you
complaints
one.
to any of the boards and commissions in this town hall about the noise and sights that you were seeing there from your house? I mean, yeah, I understand you must be objecting to it. I was just wondering if you complained about it to anybody. Just us?
Just you.
No, I didn't know if there's anybody working on it, that's not.
No, I mean, I'm kind of trying to get a full resolution here. I mean, I know that the sand pit permit's going to be up in a year.
Yeah.
I'll be back for that.
Right.
I'll have a long list and a lot of pictures and video.
You draw our own conclusions?
Enjoy your own conclusions.
Right, right. Okay, I just didn't know if there's another,
No, I mean, yeah.
a bereavement group in town that you might have talked to.
Okay, Commissioner Bauer, the particular zoning regulation that I believe the loss of adequate screening for both the pit, which is down in here in the majority of the property, and now also in this newly developed and utilized area, the 1 acre where Southern Connecticut Gas operates, but particularly in the former area, is Section 273-45 and Section 273-80. These are, I'm going to go to 80 first. These are historic properties, both Mr. Moritz's and Mrs. Fitzhugh's. Now, his is clearly the one that we're talking about right now with respect to that picture. That's the one that shows it from his bedroom windows, the pit, let alone the Southern Connecticut Gas adjoining section which has the split zone, as you've heard all night. Those two are historic properties here for Guilford, in Guilford, Connecticut, a very important character of the town. The POCD is resplendent with different statements and public policy underpinnings to the reason why preserving the character of the town is so essential. It has to do with property values for one, has to do with quality of life for another. All the kind of things that Mr. Moritz has a right to, as does Mrs. Fitzhugh. Those are lost if zoning regulations are unfairly applied, even if it might be rational in some respects, but more importantly, irrational in others, and impactful. Adverse impacts on historical properties in this town are prohibited. It's through that section of the general standards for zoning, in your zoning regulations, in particular 273-80F and the subsections within that area. And I'll read right off my letter, but you can read easily enough. Introduction of visible, audible, or atmospheric elements that are out of character with the property or alter its setting. Those are considered to create significant adverse impacts on a historic property or historic district. That is, if that's not applicable to the subject matter at hand and the core of the controversy here, I don't know what could be. So,
Defined in the zoning, I have to be honest, I haven't, is that defined in the zoning code, and does this meet?
registry.
The establishment of a special permit which shall not have a significant adverse effect on historic property or historic district. A property is considered historic if it is listed in the 81 State of Connecticut Historic Resources Inventory for the town of Guilford.
And both are.
Which is what I submitted.
Okay,
Or it's in the historic district as designated by the town of the interior.
all right.
They're not in a historic district, however.
But they meet the definition of historic property.
Yes, they do.
Okay.
And they have been designated as such officially in the town. Now, not only in this area of the property with what's going on, we now have, in effect, an industrial development, the way it has become since July 20th of 2016, less than a year ago. Because now up here in this 1 acre parcel, portion of the overall parcel B, we now have Southern Connecticut Gas with a usage pattern that could only be described as industrial usage. Whether it fits, as I said before, the ambit of a public utility substation or a satellite office or a satellite facility, call it what you want. But it is what it actually is. A rose is a rose by any other name. You know that. This is the case with the usage of this area that is being asked to be amended to be all an R5 zone, an I2 zone, because 97 feet of it on its western border of this subsection of the overall parcel is R5. But I'm going to talk about why I believe it's R5. We don't have clear documentation from the town records other than the maps, the actual official zoning maps that you have posted in Town Hall for everybody to see and everybody to get the benefit and the use of. In this case, the map that I'm talking about in particular is up on the wall, and I'm sure you've all seen it. This is a blow-up of it. And it's crucially important to the controversy at hand in that when you look at this map, and I apologize for not having a bigger version of it, when you look at this map, you can see the I2 zone that encompasses Mr. Larkins' company's parcels, or subparcel and parcel, I should say, in an I2. Also, it encompasses the White Mountain office complex next door, and next door to that, to the south, the safety zone premises that's used, both industrial usages. But what's really essential in this picture is this line to the, I'm a little directionally challenged right now, but it's to the east, I believe, that runs along and parallel to Long Hill Road. It was talked about earlier. It is set off from Long Hill Road by about 211 feet. Is that our calculation? 281 feet? in any event, we could go to Mr. Eric Anderson's map, and it can come up with a much better, the one that was admitted for you, to scale figure. But the point is, it's contiguous from its southeast corner all the way to its northeast corner. That perimeter side of the I-2 zone. It's straight and contiguous. It's not broken, it's not bent, maybe at the very end as it approaches I-95. But it is straight across, and there's a reason for that. I would posit that the reason is to keep the industrial zone activity away from all the residences, not just Mr. Moritz's. This is right here, this little tiny one, and I'll walk around pointing these out in a moment so we can make sure everybody sees it clearly. But also Mrs. Fitzhughes, that's right here. And also from the zoning, safety zoning folks across, farther away, across the street from them on the other side, the western side of Long Hill Road, you have 3 residential properties immediately across. That zone was created so those residential properties,
Right.
would not be impacted severely by the activity and have their values lost by the activities going on in the I-2 zones, legal or otherwise. This is the line I'm
Counselor,
referring to.
Your position that the placement of the zone line was intentional to provide a buffer from the industrial zone to the residential uses?
Exactly, Commissioner Meyer. The reason for that is not just so people with those industrial zones could, or is not to prohibit them from using their properties adequately, but rather to protect the adjacent neighbors, which the zoning regs are as much about as serving any one individual in their property rights, if not more, I would posit. That property, that barrier is there for a reason. It's set in from Long Hill Road to the east by about, like I said, 300 feet for a reason, and that is to protect at least 5 residential property owners in that area. That's a rational and a logical determination. If you only look at the subject applicant's property, the 325 Long Hill Road, you might scratch your head and say, geez, why did they split and have a part R5, mostly I-5, I-2 and part R5? Well, the reason is beyond its borders. It's because it's part of a larger zone, an I-5, an I-2 zone that encompasses all those larger properties I just mentioned. This is safety zone. This is White Mountain. This is Mr. Larkin's property. Here's Mr. Moritz. Here's Mrs. Fitzhughes. And these are 3 other residences across the street from the safety zone people. Their industrial area. That's not hard to contemplate why that would be rational and practical for enforcement of zoning regs that are very clear about what kind of industrial activity goes on there as it affects adjacent properties. As I mentioned, it's in the letter, it's attached to a letter. There's also another particularly germane, or relevant, I should say, section of your regulations. It's 273-45, performance standards for non-residential uses. This is particularly applicable to the section, the non-residential use in the section in the section of the overall parcel, the sub-parcel as I called it, where Southern Connecticut Gas is. The following performance standards shall apply, and forgive me for reading it out, but I think it'll help everybody who's here, shall apply to all non-residential uses of land, building, and structures, wherever located. Quoting directly. A, dust, dirt, fly ash, and smoke. No dust, dirt, fly ash, or smoke shall be emitted into the air so as to endanger the public health, safety, or general welfare, or to decrease the value or enjoyment of other property, or to constitute an objectionable source of air pollution. The next subsection, noise. With the exception of time signals and emergency signals and noise necessarily involved in the construction or demolition of buildings or other structures, no noise that is unreasonable in volume, intermittence, frequency, or shrillness shall be transmitted beyond the borders of the lot on which it originates. We haven't gotten into it much here, But if you're talking about a buffer with an R5 zone because of a split zoning, and it's part of a bigger plan of zoning, to create a buffer for residences, boy, if any reason for it, that's it right there. It's noise. Vibration, with the exception of vibration necessarily involved in the construction or demolition of buildings or other structures, no vibration shall be transmitted beyond the boundaries of the lot on which it originates. I'm going to have Mr. Moritz and Mrs. Fitzhugh, so you'll have a shot to come up here and briefly tell you what it's like to have these non-compliance elements a reality in their day-to-day living, their use and enjoyment, let alone the value of their properties. So to move this zoning line closer so that the special permit to allow, instead of 75 feet away parking of the vehicles I was talking about at the top, within 50 feet of the back line of his property, I think that's outrageous. That flies in the face of everything I just read to you. Again, I apologize for reading it, but I think it's necessary to hear it, not just see it. Not only does it fly in the face of that, but it flies in the concept of the construct that I think predecessor commissions to you folks, with your great loyalty and volunteer work for this great town, have so carefully done and managed. And thank heavens they have. Because if this zoning map change gets implemented for 325 Long Hill Road, it creates a very certain precedent for those other two industrial properties, which also are split zone, as you can well see from that drawing. They have a larger portion of R5 on them. Have they moved to make them buildable lots? I don't know. I would think not. I'd be shocked if they did. I don't know that anybody would buy them, want to buy them. They probably have the right to, because they look to me to be well over 40,000 square feet. Would they get approval to do it? I think that's another question still. So you have a plan that's in place to overlook it on behalf of one single property owner, to me, is asking to conform the Guilford zoning regs to what has evolved to be the use of Mac Management and its owner, Mr. Larkins, for his convenience, for his necessities. Yeah, there might be some benefit from Southern Connecticut Gas being able to work on this side of the river. There's a lot of land to the east of the Quinnipiac River. I think Guilford's just part of that land, the whole of Guilford, let alone my client's backyard. Don't mean to be facetious, I'm not. This is serious. These poor people have been living with this since July and even before it became approved on inaccurate information. So I would ask that the council, I respectfully request that the commissioners rather reject the zoning amendment line on the basis of your own regulations and the thrust of them, both practically applied and rationally applied based on the law, the statutes, and precedent, and what it might establish in the future were you to decide otherwise. And also reject the special permit application for parking of these vehicles that I talked about at the top, and I won't repeat, within 50 feet of his property. And therefore also closer to Ms. Fitzhugh's property. And of course, the last piece of it is just out of the decency of what you, and the public policy behind the harmony aspect of the zoning regs implementation based on the POCD. Promote compatible and sustainable economic development. It's policy C, 2.6 in the Guilford Land Acquisition Commission and your overall. Guilford, with its unique character and plan of conservation and development, the mission statement section. Commercial and industrial economic development standards should benefit the town by enhancing the vitality and character of its communal life, as well as preserving the best of its natural and built environments. And most importantly, should be guided by a comprehensive long-term economic development plan. Our Attorney Shansky beautifully articulated what the law's thrust is. This is your public policy. These are your regulations that you apply. I wouldn't be afraid of New Haven Superior Court. I think they would uphold you in rejecting this amendment and denying the applications that are part of it. And the last of 7, make that 8 bullet items, that in determining the appropriateness of future commercial and industrial economic development projects, the following criteria should be considered. Economic development should be sensitive to neighboring residential areas, if any. Well, you've seen we have them. I'm going to leave this with you folks. This is the policy I just quoted from, and the sections, and this, of course, speaks to Guilford's unique character in the plan of economic development. It shows pictures like what Carl showed you before. Agrarian, yes, way back when, but, you know, a character and a quality that's still visible and eminently appreciated in this town through the preservation of a viable plan of conservation and development. So there's that. All right, thank you. Carl, did you want to speak about the having the commercial vehicles in the vicinity of your backyard as far as the view shed?
I want to ask a question, George.
Sure.
Since I just want to make sure I understand. I think the town now has a definition of noise, and that is a noise ordinance. So when we're talking about, would it be true that when we're talking about this and the reasonableness, we would first have to define what noise is, and we've done that, and that's the noise ordinance?
Yes, the town does have a noise ordinance. It's under the auspices of the Board of Selectmen. There is a definition of noise based on measurements of ambient noise levels. The noise ordinance is enforced by the police department.
Isn't it 85 dBs?
I don't know.
It's 85.
They have to stand with the gun at the property line, I think, right?
I can only say that I approached that in another town and it was 85 dBs. Could I get those pictures back of the sand pile that you can see from the second story there, and those, because I didn't get to see those.
And I hate to do this to you, but once you're done with those points, there was a couple of things I forgot to present to you.
No.
Pictures mainly, and I think they'll be very instructive.
Okay. Did you have Commissioner, you have a question for?
I do. You know, while you're talking, I'm sorry to interrupt your train of thought. I don't mean to do that, but I need to understand something more clearly. We acted on an application in July. Did that application have the split line on it?
No.
Who presented that application to us?
Who?
Yeah, who drew up the application? There must have been a site plan or something. Who drew that up?
The engineering for the applicant, for Mac Management.
The engineer for Mac Management drew up a proposal to us that did not have a correct zoning line?
That's correct.
Well, that's why we're here now.
Yeah.
Right, but I was wondering where the genesis of it was. Where did it start? And so the applicant...
Would you send that this way, please? May I respond to that?
Oh.
Because we
I've got it
discussed-
right here, Mark.
Well, we discussed it at the very, very first time we all met. It was a mutual mistake of fact, partially derived from having relied on the assessor's record, which shows that the property is in the I-2 zoning district. It was a mistake. The commission didn't get it either. It passed by everybody's notice. And then it was discovered, and now we have embarked on a series of exercises to correct the situation.
My question is, the application must have had a map, and it must have had some indication of where the zoning line would be, no? That originated with your team, right? With the Mac Management?
Predates me, but yes, but it was operating under the belief that the assessor's record was accurate in designating the parcel I-2. Zone lines are not found hanging around the ether, so it was a mistake.
Thank you.
And the commission didn't catch it either.
Thank you.
I have the map that you were just referring to.
Could we, I'm not sure what to do here. We already spent an hour and a half on this tonight.
My suggestion is to let
the opposition finish their case in
I'm
chief?
almost done, yes,
Okay.
I have just-
Ask the public for comment. Now, I don't think we're going to be, at least I personally could never vote on this tonight, because there's a lot of material here. And then what I would ask, I think, is because of the amount of material that's come in, to continue the hearing, to allow counsel for both sides, since they've both probably just seen some of this material, to offer their rebuttals on both sides next time. And then at that point, we'll see if we have enough material to close the hearing and proceed to a vote either then or the following week, or following meeting. That would be my suggestion, if everybody's in agreement with that, to make sure everybody.
I would have to, I'm going to spend hours.
So we're gonna
reading
let
this.
them, we're gonna let you guys finish up, and then we're gonna leave.
Mr. Chairman, I think that's a fine procedure. I do need to bring to the commission's attention however, a misstatement on the regulation that has been relied upon, just so you aren't left for a week or 2 weeks
Okay.
with an erroneous belief,
So
and
when it-
I'll wait till you're done.
This is a picture of 3 of the 4 Southern Connecticut gas trucks going out the property. One's a dump truck full of the aggregate. This one, I believe, has the
They were
flatbed.
on site when we were there when.
Oh, okay, and then the box, I want to call it a utility truck.
Yep.
So I don't know if you want to.
We saw that.
Okay. This is superimposed aerial shot of the property that superimposes, this is on our part, we superimpose this for our own information. We did, Mr. Morris did. This shows roughly where the zoning line is, just to the east side. His house is right here, you can barely see it under the trees, but there, and then
Right now,
property line is along these boulders here.
Okay, and this,
And that's this
what
one.
road is this here?
That's Long Hill Road.
That's Long Hill Road.
That's Long Hill Road. So, you know, this line would have otherwise been right along here, right past the antique barn, the English hay barn. And then that's where the zoning line is. So I'll pass those both around. And this, along with the instructive view of the larger portion of property that's used for industrial purposes, this is the view out his back window, right into one of the second-story windows, right into the Southern Connecticut gas premise.
make sure the audience can see one of the pictures on your screen? That's Amanda's bedroom window.
So you can see the portalette there. You can see the fencing, chain fencing. This is right over the top of the 8-foot wooden wall, which is a beautiful fence, I should say. It's an issue yet to be resolved, but I don't think it's a big issue just yet. The Southern Connecticut gas truck is important. And then you saw the other one. I'll leave both of these. This was the pit. This is the view from the Maritz's bedroom window, Carl's bedroom window, of the large sand pit. So if this is where Carl is, right here on this map in his house, you can see, right here in the house, he looks out his bedroom window and he sees down into the pit. Those concrete bins are roughly right about this out here, right here.
No.
No, the new,
The other-
not the new
on the
ones, the
map.
old ones.
Lift the
Oh,
map.
you've got it here?
That's
Yeah.
the approved plan.
No, I'm talking about the ones that are visible in this picture. These down here. Well, both of them are
That's the
actually.
approved plan.
New and old are there.
Structure's missing.
No, they're not here. They would
What?
be down in
The
here.
bins?
Yeah,
They're right there.
No, those
these are the new ones. I'm
No.
talking about the ones that you can see in this
There's two
picture.
sets
Oh, there's that.
There's 2 sets, and actually I was wrong, you can't see them both. Here's the ones that are Southern Connecticut Gas is using, which are completely illegally placed and have been since the moment they were put there.
Since they were approved.
Before they were approved, they were there.
No. After my approval.
Oh, I stand corrected, I apologize. These have been there though, for quite a while, right? The older ones down the same thing, long time. Okay, well, those are his views. To your question,
Do we have,
Are you finished, sir?
I am.
Okay. Do we have any questions from anybody? Questions from anybody in the audience? Okay. Should we,
Well,
can we hold off comments?
I would permit, if
Comments?
Ms. Shansky wants to rebut something, and then to the extent that I would allow the other counsel to rebut what she says, just in that point, to be fair to both sides.
Okay.
Thank you. I'd be happy to defer the bulk of my rebuttal till your next meeting, but there is something, because so much of what Mr. Moritz says supports the request for the move zone line, that it's important to clarify all of those issues with you. But I want to direct you to Section 27380 of the regulations, which has been relied upon for historical purposes, and erroneously so. The special standards apply to the use of historic property for which a special permit is being requested. There's no special permit being requested for Mr. Moritz's property, ergo, the section doesn't apply. Section number 2 of 273-80 says, in considering this standard, the commission shall concern itself with the property which is the subject of the special permit application, and only in the case where the property is in a National Register Historic District will it consider impacts on property not part of the application. He is not in a National Register Historic District. The historic issues are off the table. Thank you.
Rebuttal just to that point.
Just to that point. With all due respect, I believe it's written the way it is in a strict construction of the writing. The proposed special permit use would be in conflict with the requirements that a special permit shall not have a significant adverse impact on a historic property or historic district.
This is a special permit, though. This is a zone change.
No, there is a special permit that goes along with the zoning amendment. The zoning.
But that would be appropriate at that time, but is it appropriate?
Oh, I thought it was also part and parcel to this
No, we're just
decision
talking about
tonight.
the zone change.
Oh, okay. All right. Well, but to understand the context to which you have ramifications directly applicable.
I'm sure Attorney Shansky will resubmit her position that it would be it's not the zone, it's just the property.
And with only nothing, I mean, lots more to say, but I'll wait. So much of what has been countered refers beyond the scope of the amendment to the map, and I hope when you're reading and reflecting that you will keep that in mind, because there has been conflation of future issues. Yes, we are mindful that we're here to resolve an issue having to do with a public utility substation, a permitted use in any residential zone, by the way, by special permit, but that some of the commentary made tonight is not directly relevant to the map.
Okay, one final point. Yes. I am sorry.
Is there something you can enter at the next meeting?
Well, it goes to that point, but since we are continuing,
All right.
I'll find it, but it has, well, actually, no, I do need to say it, because if you were to, well, you're not granting.
No,
I mean,
we're
you're
not
not
gonna vote.
deciding tonight.
We're not gonna vote.
We're not going to vote tonight.
I will hold it then.
I have one, can I just ask one quick question of Mr. Peck while he's here? Because I don't know if he's going to be back at the next hearing. Just in number 3 on page 7 of your report, you say that the MAC property, which is zoned R5, has no rational way of being used for typical R5 purposes. Under current regulations, the property, 30,700 square feet, could possibly be developed for other uses, all of which would be more disruptive to the existing R5 residential use. What other uses could it be developed for which would be more disruptive to the existing R5 use, so that I can think about
I
that?
think right now, there's no proposal to excavate that area, although it was originally part of a property that was permitted to be excavated, and frankly, I've seen properties where excavation takes place up to or close to the property line, so it could be excavation right in that area alone. That's not proposed at all. The other thing that could happen is, I'm sure the commission is aware, is that sometimes developers come in and they don't like your regulations, and so they just propose an 8-30G on a particular parcel. It may be totally unacceptable for that in your mind and in your regulations' eyes, but something like that could happen. The other point that I want to make, too, is that zone line that we're talking about directly abuts the lot that's on the corner of Hubbard Road and Long Hill, directly abuts it. So there was no conscious effort to remove it from any residential property.
Well, I was just wanting to know. Give me the other disrupting uses.
Sure.
So
So
those
if-
two.
if you had-
Excavation and possibly a developer coming in
Right.
with an 8-.
Yep.
Okay.
You'll probably think of a half a dozen on before your next meeting. I'll give it some thought. Okay. Thank you.
When is the next meeting at which this would be considered?
It would be February 1st?
Is that the first Wednesday in February?
I believe so.
That will be our next regular meeting.
February 1st.
And will the special permit still be on February 15th, or is that going to be
That's
not?
That's up to you all, I guess. That's what it's scheduled for. We can, is that, you would want it to be heard then?
Well, I just am asking about posting and
Haven't really
notices.
thought about it.
Perhaps we can talk about that. Thank you.
Okay.
Can I just very, very briefly, while Mr. Peck is here, would it be fair to rebut his very last point without him here?
I think that's fair.
Okay.
Opportunity to do that.
He is exactly correct, and I should have stated that Mrs. Fitzhugh's property, it is, the I-2 zone line does go immediately on the eastern border of her property, which beyond that to the east is the large White Mountain, you all know it, large White Mountain commercial office building, right? Okay. When they put that line there, I think they used Mrs. Fitzhugh's property actually as the most significant and germane necessity of putting it there instead of splitting her property and making her part of an I-5,
so you're
a split
speculating.
parcel. I'm speculating, but that map is clear. It is right on her boundary line.
What we go by.
Right, and because her house is on the front of the property, like most historic houses would be, as is Carl's, about the same amount set back from Long Hill Road, then she has a large expanse of land behind her all the way to her property line. That creates the buffer for her, and it happens to be on her whole property. I would posit, if you were to keep the line straight across everybody and put it right to where you are, or where the applicant would want you to put it, and you drew it straight across, you would then make her a split parcel. Now, of course, you wouldn't do that, but then you wouldn't be part of a comprehensive sub-plan, so to speak, that involves not just this property, but the other ones in the I-2 zone in that area.
Okay. Could I have a motion to continue this till February 1st? So moved.
Second.
All in favor, say aye. Aye. Okay. Okay, next up, 10.
Can we take a 5-minute break?
How far are you on the tape, Peter? You gotta go? We're gonna take a 5-minute break and then we'll come back then. Just stop.
Yeah, I'm not voting tonight.
Okay, we're back in session, no business. It was transacted while we were off camera. We're going to the next application, which is 10 Long Hill Road LLC. It's at 10 Long Hill Road, map 45, lot 14, zone C2, coastal area management and site plan revision, change of use from retail to professional offices and site improvements. Please introduce yourself.
Good evening, Mr. Chairman, members of the commission. For the record, my name is Michael Harkin. I'm a professional engineer and principal of Harkin Engineering, located at 78 Wolf Hollow Lane in the town of Killingworth, Connecticut. Here tonight on behalf of my client, 10 Long Hill Road LLC, for their project, which is located at 10 Long Hill Road. 10 Long Hill Road LLC, the principal is Dr. Deborah Pan, who's in the audience tonight. Also with me is Karen Petrican, the architect, and Petrican Architects is located in New Haven, Connecticut. The civil engineer of record, again, is Michael Harkin, Harkin Engineering LLC. The surveyor of record is Mr. Eric Anderson of Anderson Engineering and Surveying Associates here in Guilford. The subject parcel, just to familiarize ourselves with the site, it's located on the corner of Long Hill Road and Boston Post Road. The town just recently did a major rehaul of Long Hill Road. This is right at the tip where the stoplight is. The current owner of the property is Fusco Management LLC out of New Haven. The applicant is, again, 10 Long Hill Road LLC. Dr. Pan, doctor wishes to potentially purchase the property and switch the use from the old antique retail use to a medical facility. Real briefly, Dr. Pan's business, and she can elaborate more on it, it's a plastic surgery type of establishment, so that's what's looking to come in there. It's only going to be open 3 to 4 days a week right now. The main office, I believe, is in New Haven, so this is going to be, in between office. Any questions about the physical use? Dr. Pan, again, is here to answer those questions. The site plan itself is pretty simple. There's not really much going on the site. Right now, the pavement is basically worn down. The pavement markings are non-existent. So what we're proposing is to spray the pavement markers back in to get the required amount of parking spaces, to designate that handicap space better, put up a new handicap sign. Additionally, what we're looking at doing is putting traffic arrows for the flow. And we're going to be changing the area on Long Hill Road. Right now, it's two-way traffic. We're going to make it one-way traffic, just because it's not really wide enough to have 2 cars going in and out, especially with parking there. We put the turning radius of a fire truck on there just to make sure it can get around there. With that radius, there's a small little area that we call out. It's our note 0 on there. That's going to be a proposed new area of pavement. That's just to really make sure that any large-scale vehicle can get that turning radius around there. Additionally, besides the pavement markings, we have a small stairway in the back of the building that's going to be new. It's just a set of steps that gains access from the second floor down. Additionally, on the site, we're going to be putting in a couple signs, stop signs and do not enter signs just for traffic flow. And lastly, on the site, we propose an emergency generator location that is located to the westerly portion of the rear of the building. I'd like to submit the specs for the generator. That generator meets the Town of Guilford planning and zoning requirements for decibel levels. And it's important to note that the project itself, we meet all the parking requirements for that zone and that establishment that we're producing the medical use. We also meet all the health department requirements. We did a detailed analysis of the septic system. I think the record will show that a letter has been submitted by Mr. Dennis Johnson approving the use. Sure, that would be great, thank you.
I'll just read it. Did you get it? It's dated today.
I did not get it.
Okay, you could take this, I guess. Okay, so to the Planning and Zoning Commission from Dennis Johnson, the applicant's dated today. The applicant's proposed medical office facility will occupy the floor area of the existing building. Soil test results and an as-built septic records indicate that the adequate septic system capacity exists in the current septic system for the proposed use. It is recommended that the applicant's proposed site plan improvements be approved.
While we're at it, I think we also have one from Kevin McGee, dated January 5th. The applicant is proposing to install wooden steps behind the building, install a backup generator, create additional parking spaces, and restripe existing parking spaces. The installation of the deck is located in a FEMA AE10 flood hazard area and requires an Inland Wetlands Commission agent approval for its construction. The work being conducted has a minor impact on the adjacent coastal resources. In order to make sure that the coastal resources are protected during the construction process, I recommend the following condition of approval. Any material removed as part of the pavement expansion be placed in a truck and transported off-site. If the material is not disposed off-site on the day of excavation, soil and erosion control measures shall be instituted around the soil pile and excavated area. And you're okay with that condition?
Absolutely.
Perfect.
That's something that Kevin had discussed with me, and we are.
That's before you looked at it and conforms to all the zoning regulations? Okay.
This is actually probably going to be a reduced in use, right?
Probably.
For at least for traffic purposes.
Traffic, correct. The parking spaces you see there, they're pretty much pre-existing already, they're just not designated. So that's that aspect of the site plan. Because we are actually in a CAM zone, we have to do a CAM application as well and send it up to DEP. It's kind of interesting that we learned this section per the survey is the West River, not only 50 feet down, the Mill River comes in and intersects it. So you have the confluence right at our project site, right at the bridge over in here. So on two different maps, it says two different things. So with our CAM application, on one of the spots, for clarity, this is one of the comments for CAM, we had put West River down, but on one of the sheets, we had indicated that it was the Mill River. So for clarity, they asked that we submit a revised sheet, which we have right here, which takes the Mill River out and puts it the West River, just so everything for the record is 100% complete. The second item that the CAM had asked us via their letter is to designate the coastal hazard flood zone. We had already shown the coastal hazard flood zone on there. I don't know if they missed it or didn't see it clearly, but we physically renamed it and put a call out there so it was, pretty clear to everybody, no 18, coastal hazard zone line AE10. And lastly, they questioned the existing building finish floor elevation, which was on the plan as well. They didn't see it. So what we did is boxed it out and made it darker. So those were the three comments from CAM. They didn't have any additional comments. We sent them up there. We have not received the letter back, but we handled all the little questions that they had brought up to us or discrepancies, and then submitted it, and now it's a complete application. So with that being said, I would like to introduce Karen, the architect on the project, and she can go over the architectural features of the site.
Thank you, Michael, and good evening. My name is Karen Patrickman of Patrickman Architects. I'm a Guilford resident and the chair of the DRC committee. This is very quick for our portion because we're really not doing very much at all on the exterior. We have, I'll just show you some on the pictures here. There's a little bit of repair work to these columns. There is an exterior area here that masks, actually two areas that mask mechanical units, and we're going to be locating the new mechanical units behind those. So there's nothing visible to the public that changes. We have a little staircase here that Michael already mentioned that we will be designing. I just spoke to George earlier. When it comes to permitting, if there are any other changes, we will be going before the DRC. But otherwise, there's really nothing. You can see there's already existing plantings that are in good shape. Whether or not we will just be adding in, but really on the exterior, other than this generator that Michael mentioned already, there are really no other changes.
And lastly, just to make sure that the record's complete, we did post the sign that's required for this. We did take a picture and we sent it to Reggie. It was stamped in, as well as the mailings. It's also important to note that I was notified by the attorney of the adjacent property owner for the estate of Basil Duncan, who was Mr. Tom Cronin. He asked me a couple questions. He asked me about the generator, and he was satisfied with everything.
So this did not go before design review?
No.
Didn't have to.
Yeah, that's what.
Yeah, Reggie and I spoke about the scope.
It's one of the conditions, though, in the proposed motion that it go before there. Is that still accurate?
To review any final, if there are any final changes, before they get a building permit.
And you don't have a problem with that condition?
No.
You just recuse yourself, right?
Okay. Any other questions from the commission?
I'm good.
Ma'am, you came to the meeting. Is there anything you'd like to add while you're here?
Sure. I'll introduce myself. I'm Dr. Deborah Pan. I'm a plastic surgeon in practice now for about 13 years in downtown New Haven. I'm now a resident of Guilford for the past 6 years, and my husband grew up in Guilford as well. This is basically an expansion of our current business. We will be using it to see consultations and offering high-end medical skincare services to the east of the bridge clientele who are very reluctant to come into New Haven. So we found this to be just a very practical expansion in the direction of our practice. I've eyed the building many times driving up and down Boston Post Road, found it to be a beautiful building, and we found the opportunity. So, all right. Thank you very much.
Thank you.
Any questions or comments from anybody in the audience? Brian? Go Steelers.
No, I mean, to add, it is a relatively benign use. I don't think you're going to see traffic issues here. I'm guessing that, there's only probably a few customers at a given time, so parking shouldn't be a problem, traffic shouldn't be a problem. It's architecturally a beautiful building. They're not making any changes. They'll just keep after it and enhance it, I think. So I think it'd be a good change of use.
Thank you. Would someone like to close?
I'll make a motion, we close the public hearing.
All in favor, say aye.
Aye.
Okay, we're going to move on to the revised agenda.
Make a motion,
Make a motion to approve the revised agenda.
Second.
All in favor, say aye.
Aye.
Okay, the deliberation.
I'll make a motion. Voted that the Guilford Planning and Zoning Commission approve the site plan revision and coastal area management plan for 10 Long Hill Road LLC. At 10 Long Hill Road, map 45, lot 14 is shown on site plan improvements, 10 Long Hill Road LLC, prepared by Harking Engineering, dated 11/30/16, revised to 12/6/16, and proposed medical office, 10 Long Hill Road architectural plans, 5 sheets, dated December 5th, 2016, prepared by Patrick Quinn Architects. The application is approved with the following conditions. Number one, that prior to approval of a building permit, final architectural landscape plans be reviewed with the Design Review Committee. And number two, any material removed as part of the pavement expansion be placed in a truck and transported off-site. If the material is not disposed of off-site on the day of the excavation, soil and erosion control measures shall be instituted around the soil pile and excavated area. This application is approved based upon a finding that it conforms with the zoning code and is consistent with the coastal management policies of the state of Connecticut.
Second.
Any discussion?
This is pretty straightforward.
Okay. All those in favor say aye.
Aye.
There's no no's.
What happened to George?
Went home.
We thank you for your time, everybody. Have a great
Thank you.
Thank you. The question of the day, yes, I'm George.
Okay, let's move on to subdivision. South Central Connecticut Regional Water Authority, 1115 Great Hill Road, map 121, lot 12, zone R8, subdivision application to cut out an 80,360 square foot lot out of 476 acres. The property lot contains house, septic, and well. Hello, sir. How are you?
Not too bad. Good evening, ladies and gentlemen. My name is James DeMayo. I'm a civil engineer and surveyor for Giuliano Associates. We're located at 405 Main Street in Wallingford. I'm representing John Triana, who's also part of the Regional Water Authority. And they currently have, and I'll try to make this quick because I know I'm tired too. They have a piece of property that is 476 acres with a house on it, an existing house. Essentially what they want to do, they don't want to be landlords anymore. So they're trying to create the lot and get rid of it, is essentially what they're doing. This property already had the first split done on it previously, which is why we're in front of you now for a subdivision. The proposed lot conforms with zoning for an R7 zone in every way except for the fact that the building is too close to the front setback. Can't really do much about that because it's a pre-existing building. And aside from that, the well is, the septic is good. There's an existing well. We had to prove that we can support a new septic system in case the existing one fails. So that's why on the map there is a proposed septic system. However, there is no work being done. That's just proving that this property can support it. Aside from that, there's really nothing being done, just drawing some lines.
Received Dennis Johnson's letter today, actually.
No, sir, I did not.
Yesterday, I've been saying today for the 17th, but today is the 18th.
No, sir, I did not.
He wrote a letter about your exact point, and I'll read it into the record now.
Thank you.
Soil test conducted on the applicant's proposed lot on October 3rd, 2016 revealed the presence of suitable soil for installation of a septic system. An engineered design septic plan prepared by Giuliano Associates LLC dated 10/20/16 has been prepared and approved for installation of a new septic system should the existing septic system need to be replaced or repaired in the future. Based upon soil test results and site plan review, it is recommended that the applicant's proposed lot subdivision be approved. Do you want this?
No.
Another one here, Kevin McGee, the environmental planner, dated yesterday. From Kevin McGee, environmental planner, subdivision, South Central Water Authority, 1115 Great Hill Road, Guilford, Connecticut, assessors map 121, lot 12. South Central Water Authority is proposing to cut an 80,306 square foot lot with an existing house septic system and well out of a 476 acre parcel. At its inland wetlands meeting on December 14, 2016, the Guilford Inland Wetlands Commission took the following action. Voted, the Guilford Inland Wetlands Commission refers favorably to the Planning and Zoning Commission the subdivision on map titled Limited Property Boundary Survey Subdivision Map Land of South Central Water Regional Water Authority, 1115 Great Hill Road, Guilford, Connecticut, dated 7/29/16, last revised 11/11/17, prepared by Giuliano Associates.
Yep, just for the record, wetlands did have a couple comments. There's a little discrepancy with the marking of the wetlands, which is why this map is highlighted. This is the exact map that I used for that presentation. I didn't make the revisions on this map yet, because I was waiting to see if there was any other comments that this commission had. But essentially, just so you know, the flags that were previously put out there by the soil scientists, the Wetland Commission disagreed with, which are these flags right here. So we're calling this the wetland boundary, and this will be the new 100-foot setback. Not that it's a concern of this commission, but I just felt the urge to just explain everything. Any questions?
It's a 100-foot setback?
Yeah. Yeah, well, a 100-foot upland review area
Okay.
is what they have. Yes, sir.
For the sake of what we've been through tonight, are we all within one zoning district? Are we leaving any parcels of land that might create a future problem?
Technically, the 700, or the big parcel of the Regional Water Authority is an R8 zone. We're taking this property out and making it an R7, which we are allowed to do for the first two lots. So we already did one previously, so now we're making this an R7, and it's surrounded by the R8.
It doesn't actually change the zone to R7, it's just, in the R8 zone, you're allowed to create two lots that meet the minimum standard of the R7 zone.
So that's still an R8 zone, it'd
Yes.
just be non-conforming.
That's the clarification.
Very
conforming.
awkward,
It's conforming, because they're allowed under the code, you can have up to 2 R7
Correct.
lots when you subdivide that.
So why that was done that way, I have no idea.
No, that's not going to
So
go
the
there.
so the remaining 476 acres is now
It was a compromise.
not permitted to be subdivided further?
Oh, no.
It can.
Yeah.
It's just,
They can't make any more.
we can't create another R7 lot off of that R8.
R7 size lot.
R7 size lot off of the R8, sorry.
It's a lot of land. A lot of people.
Yeah, and I don't foresee them selling their big land or changing the use of that, so.
Any more questions? I'm good. I'll make a motion. Voted that the Guilford Planning and Zoning Commission approve a subdivision application for the South Central CT Regional Water Authority, 115 Great Hill, or 1115 Great Hill, Road Map 121, Lot 12, as shown on limited property boundary survey, subdivision map land of South Central Connecticut Regional Water Authority, prepared by Giuliano Associates, dated 7/29/2016, revised to 10/24/16. This application is approved based upon a finding that it conforms with the subdivision and zoning codes of the town of Guilford. The approval is effective on January 27th, 2017, and upon filing with the town clerk.
Second.
All in favor, say aye.
Aye.
Anybody opposed? Nope. Okay. We're going to move on to receiving applications. One is, A is special permitted Shabbat Lebuevich of the Shoreline, Inc., 2710 Boston Post Road, map 83, lot 42B, zone TS3 and R8, special permit and site plan, establish a place of worship, 273-79, 273-97, receive and set public hearing date of 2/15, continue to 3/1 for mandatory second public hearing. All in favor, say aye. Aye. Coastal area site plan, Matthew Bauer, C. Bauer, 182 Leeds Island Road, map 20, lot 7, zone R5, coastal area management to reconfigure the access to the house from the existing driveway and detached garage. Receive and set public hearing date of 2/1. Second. All in favor, say aye.
Aye.
What we got left?
Zoning amendment.
Zoning amendment. Amendment Article 32, Transition and Service Zone District 3, 273-253 Permitted Uses. A. One in parenthesis, no, those are, what are those called?
Parentheses.
Yeah, parentheses, to read, quote, dwelling units not to exceed 5 units per acre with total building area of not to exceed 5,000 square feet per acre. Receive and set public hearing date of 2/1 to be continued to 2/15.
Second.
All in favor, say aye.
I'm off on that one. I think it's supposed to read TS3 though, right?
Yes.
It says District 3.
Transition and service.
District number 3. Good.
But I'm off on
Okay.
it.
Mr. Chairman, I
Yes,
make a
what-
motion that we pay the bills to Shore Publishing for $298.41.
Second.
All in favor, say aye.
Aye.
Mr. Chairman,
Yes.
I have reviewed the minutes on 1/4 for the regular meeting, and I make a motion that we approve them as they are substantially correct.
Second?
All in favor, say aye.
Aye.
That's
Mr. Chairman, inasmuch as there's no more business before the commission, I make a motion that we close this meeting.
Second, please. All in favor, say aye. Aye. Okay, thank you very much. Sorry for the length.
That's why I always say.